Hi, everyone. Thanks so much for joining. We're going to give our other attendees a couple more minutes and we'll start just past 11. Thanks. All right. I think we can go ahead and get started. Thanks so much for joining, everyone. So good morning. My name is Danica Hobza, and I am the volunteer coordinator with AIDS Legal Referral Panel. Today we have with us Lark Ritson. She's the Project Sentinel Enforcement and Litigation Director. She will be presenting on handling affirmative fair housing violations. So this is our second MCLE to commemorate Fair Housing Month, and this year is the 54th anniversary of the Fair Housing Act, the landmark civil rights law that made discrimination in housing transactions unlawful. And this month just reminds us that the principle of fair housing is not simply state and national law, but a right for everyone. So let's go ahead and dive in. I'll go ahead and kick things off with an introduction. I'll give a brief overview of my organization, ALRP. I'll introduce today's presenter. We'll go through the training, and then we will have time for questions at the end. First, a couple of acknowledgements. I do want to thank the HIV Legal Services Fund of the American Bar Association HIV/AIDS Impact Project for their generous support. Their funds make it possible for us to bring you this presentation today. I would also like to thank Project Sentinel for their partnership in bringing you this MCLE. A couple housekeeping items. We are recording this training. If you have questions during the training, you can enter them into the Q&A function that's found in the middle of the Zoom toolbar. We will go through your questions at the end. And then lastly, in order to receive CLE credit and a CLE certificate, you must complete our evaluation. The evaluation will automatically open up in your browser window once the webinar is over. I will also send that out by email. Once you complete that and send me your responses, I will be sending out those certificates early next week. Like I mentioned, we do record our MCLE trainings and we do post them online. Our website is a CLE Heroes site. That URL is on the screen now. You can view our past trainings on demand and also receive CLE credit that way. So now I'll provide just a brief introduction to AIDS Legal Referral Panel. So we were founded in 1983 in response to the AIDS epidemic. And at that time, our organization was just 4 attorneys drafting wills and durable powers of attorney for those who were dying of AIDS. Drafting legal documents like this allowed these individuals to fulfill their wishes about healthcare and disposition of assets. Since then, the needs of our clients have changed and evolved, and our organization has as well. We have supported clients with over 80,000 different legal matters since our founding. We offer both direct services in-house with our staff and operate as a lawyer referral panel. We have a large panel of diverse and a very diverse community of attorneys. Between our staff and our panel, we're able to help our clients with a wide variety of legal matters, just to name a few: housing, immigration, employment, and insurance. But there's many more. Our goal in offering these trainings really is twofold. First, we do hope to recruit new talent to our panel to help us meet the legal needs of those living with HIV or AIDS in the San Francisco Bay Area. But in addition, we do hope to help increase the capacity of attorneys throughout the country who are serving those living with HIV or AIDS. Just to share a little more background on how the process works. As an attorney on our panel, you play a really critical role in helping us provide low-cost legal counseling and representation to our clients. As an attorney on our panel, we just ask that you accept 2 referrals a year, and you always have the option to pass on a referral if you can't take on a new client at that time. We conduct a really thorough intake with each client and then make an appropriate referral based on your expertise and your availability. There are lots of benefits to being on our panel, but just to name a couple: you have access to these free MCLE trainings, you're covered by our insurance, and there's networking opportunities as well. If you would like to join the panel, please don't hesitate to reach out to me. My email's on this slide, and you can also find it online along with our panel application. All right, so now I will go ahead and introduce today's presenter, Lark Ritson. Lark is the Litigation and Enforcement Director at Project Sentinel. She oversees enforcement cases in which administrative complaints are filed with the Department of Housing and Urban Development or the California Department of Fair Employment and Housing. Lark also oversees the referral of fair housing discrimination cases to panel attorneys for litigation in federal or California state courts. Lark has practiced law for over 35 years. Her practice has included administrative tribunals and federal and California state trial and appellate courts. She has represented both tenants and property owners and litigated fair housing matters in federal district courts. She's a graduate of the University of California at Davis Law School. She also holds bachelor's and master's degrees in literature from University of California at San Diego and San Diego State University. And with that, I will go ahead and turn things over to our presenter. Lark, thank you so much for being here today.
Thank you for having me, Danica, and thank you to ALRP for hosting this training. As Danica said, I'm the Litigation Enforcement Director for Project Sentinel. Project Sentinel is a fair housing nonprofit organization. We've been in existence over 42 years now, starting with a 2-person entity and growing from there. At this point, we have not only a fair housing division, but we have a landlord-tenant mediation division. We have a division that helps clients with their mortgages, either first mortgages or refinances. And we have a division that helps connect clients to the courts, mediation, and alternative dispute resolution process in certain of the Bay Area counties. With that, this training is on handling affirmative fair housing violations in federal or state court. And let's go from there. So if we can move to the second slide. Project Sentinel's mission is to develop and promote fairness and equality of housing for all, and to advocate peaceful resolution of disputes. We do that in our process of intake and assignment of cases in-house in our Fair Housing Division. Many of those cases are negotiated and resolved peacefully through conciliation and education. Some cases are put into enforcement actions with the Department of Housing and Urban Development, or HUD, or with the California Department of Fair Employment and Housing, DFEH. Those are administrative actions before the agency, which may be filed within 1 year of the discriminatory action. If the case does not seem suitable for an agency complaint, then we seek out our panel of attorneys who we refer cases to. And I would like to invite interested attendees to please contact us about becoming one of those panel attorneys. Anyway, before we do a referral, the case has been thoroughly investigated. We've developed evidence of the discriminatory act. We may have tested for the act. We're ready and fairly confident that the case would make a good case for court and has a potential for settling or going to a successful judgment. We also choose cases because of their impact on the community and on the housing providers in that jurisdiction. So cases that are likely to have some impact are referred for litigation. By way of an example, we have a recent case that's now in settlement process. This is a familial status discrimination case. It involves quite a number of property managers and apartment complexes in the Bay Area. We brought the action initially on behalf of a handful of clients before DFEH, and somewhat unusually, they took it on as a direct action, which they filed in federal court. Our panel attorney, who was then representing our clients as well as ourselves, filed complaints and intervention. Those complaints allowed the clients to collect their damages and Project Sentinel to collect its damages, which are basically the disbursement of our funds for investigating and testing a case, as well as our own staff time. The facts of this case are somewhat interesting. They involved a written policy that required parents to supervise their minor children at all times when they were in common areas of the apartment complexes or in apartment grounds, including playgrounds. That policy was also enforced by on-site housing managers who would encourage children to return to their home when they were not with their parents, who would actually tell them scary stories about boogeymen and things that might happen to them that were bad if they didn't return to their apartment. These housing providers also had a policy of collecting toys that they found on the grounds, including expensive toys like bicycles, and they would throw them away without contacting the parents. The case is now settling for several $1 million, and our clients in Project Sentinel have recovered, and our panel attorney is recovering attorney's fees and cost. So that is a very successful case. Could we move to the next slide, please? This presentation is going to focus on the Federal Fair Housing Act. There is also fair housing law that is a state law in California where Project Sentinel is located. And I imagine as to attorneys that are from other states, they have their own fair housing laws as well. But the Federal Fair Housing Act, again, which originally was enacted in 1968 as part of the civil rights legislation, is a basis for all the other state statutory schemes. So an understanding of the Federal Fair Housing Act will provide you with a good basis in state law as well. The Federal Fair Housing Act is enacted at Title 42 of the United States Code, sections 3601 through 3619, and Part 2 is a single statute 3631. This slide presents the policy of the Fair Housing Act, which is to provide within constitutional limitations for fair housing throughout the United States. Section 3602 is a list of the definitions of the Fair Housing Act. And I'm going to point out a couple that I think are important. There is the definition for a dwelling, which we'll show later on. There is the definition of what is rented housing. So a renter is a person that holds a lease or a rental agreement, or gives consideration for the rights to that dwelling. And there's also a definition for who is a protected person, and that who is a complainant. And protected people include not only individuals, but entities. An important definition within 3602 is subdivision F, which defines discriminatory housing practice. And it defines it by just pointing to these sections in the act that do define discriminatory acts. And those acts, those sections are 3604, 3605, 3606, and 3617, which we will discuss in this presentation. Most of our complaint cases, both in litigation and enforcement actions, are brought under 3604. And this defines a person as who has fair housing rights to include a prospective buyer, a buyer, a prospective tenant, and an existing tenant. A person, again, is defined as one or more individuals, corporations, partnerships, associations, labor organizations, legal representatives, mutual companies, joint stock companies, trust, unincorporated organizations, trustees, and trustees in cases under Title 11, receivers and fiduciaries. I guess the point of reading all of that is to show you that this is a very broad definition and may incorporate entities and groups of individuals. To rent includes to lease, to sublease, to let, and otherwise to grant for a consideration, and that's an important point for consideration, the right to occupy premises not owned by the occupant. Going on to the next slide. Fair housing rights are rights to a dwelling. And dwelling has a statutory meaning. It means a building or a structure or a portion of a building or a structure designed or intended for occupancy as a residency for one or more families. That definition includes vacant land that is offered for sale or lease for the construction of a dwelling. Going on to the next slide. Then again, under 3604, where most of our casework originates, the protections for an individual or individuals or entities applies to their rights to sell or purchase or rent housing free of any discrimination based on race, color, religion, sex, familial status, national origin, handicap, or disability. The term handicap is used in the Fair Housing Act. Disability is often used in the state law, in California law. Handicap includes both physical and mental disabilities. And I think at this point, it's important to talk about what those classifications mean. We hear them a lot, but it's important to take a little time to think about what is meant by race, color, religion, sex, familial status, national origin, handicap, or disability. Race discrimination happens when housing providers treat tenants differently because of their race, whether that's white or black or Asian or American Indian, Alaskan Native, Native Hawaiian or Pacific Islander, or a combination of those races. And in thinking about discrimination, I'd like to make a differentiation between bias and discrimination. So we all hold biases. It's part of being a human. Some of those biases we're aware of, some we are not until we're confronted with the situation. But the Fair Housing Act protects against discrimination. And that occurs when people are treated differently based on their inclusion in one of these protected classes. Color has a lot to do with, or is very similar to race, but it has to do with the color of one's skin. Religion is based on the religion one holds or does not hold. It protects both belief and disbelief. Sex will include a number of situations. Housing providers cannot prefer men over women or vice versa. Housing providers or their employees may not sexually harass tenants or allow tenants to harass each other. They may have a duty to act if they become aware of these situations. And sex discrimination also includes discrimination against victims of domestic abuse. So because someone has been a victim of domestic abuse is not a basis for denying them housing. Familial status concerns families with minor children. The definition of family is broader than what one might initially think. It includes a single individual. It includes married people or unmarried people. But a familial status discrimination case will always involve a minor child, whether that is a child of parents, of a single parent, of a grandparents, or of a legal guardian. What we find often in dealing with familial status cases is that housing providers may act from a sense of protection for children, but they're confusing their roles as housing providers with parental roles. So where they may believe that a particular apartment or housing complex is not suitable for a child, that is not their decision, that is the parent's decision. Also, supervision in common grounds, outside, in clubhouse facilities and so forth, that is up to the parent, and rules should be applied evenly among all tenants, including families with minor children. The exception to the familial status rule is in 3607 for housing for older persons, including housing that qualifies as 55 or older housing and meets the specific requirements that are set out in 3607, and housing that is limited to persons who are 62 years or older. National origin discrimination, I tend to group with race, color, and national origin, but it was added later, so it comes later in the statute. National origin is based on where someone is from. It also encompasses that person's culture, and it involves discrimination based on differences in origin and differences in culture. Sometimes we have cases where we find stereotypes against a particular culture. One group is stereotyped is perhaps noisier than other groups, or more aggressive, or more likely to violate lease rules, or more likely not to pay their rents, or more likely to offend other neighbors in the same complex. And that is national origin discrimination. Under California law, which is somewhat broader than the federal law, we also have protections for people based on their immigration status. So that would fall within a national origin discrimination. The final category is handicap or disability. That includes both physical and mental disability. And in that, we see discrimination in renting or selling dwellings to people with disabilities, or discrimination in providing services to those people. Under that, there's rights to reasonable accommodations in services so that a tenant with a disability may enjoy their tenancy in the same manner that other tenants enjoy their tenancies. Services may include something like an accommodation for parking closer to the person's apartment. Someone who has a mobility disability may need closer parking. It may also include such things as an extension of time to quit the premises because of the disability, a need to have more time to move out. A frequent accommodation that we deal with is an accommodation for an emotional support animal or for a service animal. There is also rights to reasonable modifications. For instance, someone who's wheelchair bound may need a ramp. If it's purely private housing, generally they're going to have to pay for those modifications of their apartment. That may include things like lowering the counters for wheelchairs, access to counters. If it's federal grant housing, there is a provision that might require the housing to actually pay for the cost of the modification. So in housing that comes under federal grants, home grants, the housing provider may have duties to accommodate for accessibility and to make other accommodations for that person. Can we move on to the next slide, please? So the question is, what is prohibited by the Fair Housing Act? And what is prohibited is based on a person's belonging to a protected class, race, color, religion, sex, handicap, familial status, or national origin. So based on their belonging to one of those protected classifications, it is prohibited to refuse to sell or rent to the person after making a bona fide offer, or to refuse to negotiate to sell or rent, or to somehow otherwise make or deny availability of a dwelling to that person. It's illegal to discriminate against a person in the terms, conditions, or privileges associated with the rental of a dwelling or associated with the purchase of the house. In the provision of the services and facilities connected to that dwelling. Services, again, would apply to such things as as parking spaces, as access to swimming pools, clubhouses, playgrounds. So one group cannot be discriminated against in those provision of services where another group has access to them. It's also illegal to make, print, or publish notices or statements or advertisements with respect to the sale or rental of a dwelling that indicates a preference as to who would be allowed to live there, or eliminate a limitation or a discrimination based on one of the protected classes. It's illegal to represent to any person that because of their race, color, religion, sex, handicap, familial status, or national origin, that a dwelling is not available for inspection, sale, or rental. This is often the case of what is referred to as steering in the case law, where certain groups will be steered away from housing, maybe from one neighborhood into another neighborhood, or from one building to another building because of their belonging to a protected classification. Can we move to the next slide, please? There are some jurisdictional limitations to who may bring a Fair Housing Act claim. Fair housing doesn't apply to a single family house that is sold or rented by that house's owner, provided that the owner does not own all or an interest in more than three single family homes, provided that they do not sell any one home more than once in 24 months' time, provided that they do not use the services of a real estate business or agency in renting or selling the property, because the fair housing requirements will apply to that business, to that rental estate agent, or to that property manager. And provided that the owner does not himself or herself advertise or publish notices that violate Section 3604 by advertising that the housing is only for adults, for instance, or advertising that the housing, there's a preference for who may apply to the housing by race or color or national origin, even such things as only putting an advertisement up on a community board that will only be seen by a certain community of people can qualify as a violation of this section. So let's go on to the next slide. Another jurisdictional limitation is referred to as a roommate rule. If the owner maintains or occupies a room or a unit in a dwelling that contains no more than 4 families living together or independently of each other, then that owner is exempt from the fair housing laws. This situation is intended to allow people to choose their own roommates if they're sharing facilities, sharing kitchens, sharing bathrooms, sharing a unit. Let's move on to the next slide.
And Lark, just a quick time check. We're at 30 minutes.
Thank you. The statute of limitations, there are 2 statute of limitations. One is for administrative action filed with HUD, and that is 1 year, no later than 1 year than the last act of alleged discrimination. For an action that's filed in court, there's a 2-year statute of limitations. And again, from the last act, that 2-year period is told or stopped during the time when an action is pending before HUD or before DFEH for determination. So in counting the time, all the time that was spent before in the agency will be taken out of the calculation of that 2 years. An aggrieved person may file a civil action for fair housing discrimination in federal district court or state court. An aggrieved person includes anyone who claims to have been injured by a discriminatory housing practice, and anyone who believes that they are facing imminent injury or damages. Those sections are set out in 3602 and 3613. The aggrieved person definition takes into account not only injury in the terms of damages, but injury in terms of relief that might be needed, affirmative relief, restraining orders, or that prevent this type of action from occurring in the future, or if it's about to occur, from taking place. Can we move on to the next slide, please? I wanted to discuss the intersection of discriminations in Project Sentinel's case intake. We often see cases that have a number of protected classifications and concerns. There may be discrimination based on race or color or national origin, and that discrimination may be complicated by the fact that it's a family with minor children. It may be complicated by the fact that the individual tenant or the tenant's family or children have disabilities. It may be a whole mix of things that results in discrimination and retaliation by a property manager or by neighbors. These cases can get quite complicated. Generally, in preparing a case for administrative action and for a litigation, we tend to try to focus in on the most evident type of discrimination in that particular case. That may be race or religion, sex or disability, but we want to focus the case so it will be stronger. And in this, Project Sentinel qualifies under Section 3616A, Subdivision H, as a qualified fair housing enforcement organization. And within that section, you will see certain requirements for complaint intake, complaint investigation, and for testing for fair housing violations and enforcement of meritorious claims. Our fair housing division has intake staff who are trained to listen to callers, to hear their stories, to be very patient, and to note what sounds like a discrimination action. That intake staff brings those cases to our staff attorneys and to our fair housing coordinators, and cases are assigned out for investigation. Initially, we're always interested in seeing if we can't negotiate and resolve the case peacefully, often through communications with the housing owner or housing manager, and with the tenant, also with education letters, so that either side, both housing providers and housing managers and tenants are educated in the rights for fair housing. Often we do conciliate cases, and we're very pleased when that happens. If not, we will be looking to develop evidence for a administrative complaint or for a court case complaint. And so we're looking to develop admissible evidence, including documents and testimony of clients, testimony of tenants, testimony of fair housing providers and project management. And we also have a civil rights investigative staff that develops tests and surveys and hires subcontractors to go out and perform those tests and perform those surveys. And that under the Fair Housing Act and under the case law is admissible evidence. So that will strongly develop a case. There are standards for reliability for tests and for surveys, and there's quite a bit of case law on those standards. Moving on to the next slide. In taking a case into litigation with one of our panel attorneys or panel firms, we also want to look at what damages, what injunctive relief, and what attorney's fees and costs are available. And we like to say that the Fair Housing Act has teeth. There are other schemes that regulate landlords and tenants, where there's very little that actually enforces the laws, notice laws or that apply to landlords and tenants, for instance. But the Fair Housing Act has a number of enforcement provisions. Under that act, is looking at section 3613, you will see that you have a right to actual and punitive damages. You have a right to seek permanent or temporary injunctive relief and restraining orders. That those types of relief can be not only an order restraining someone from doing something, but affirmative orders requiring a defendant to not only not continue to engage in discriminatory practices, but to take affirmative steps such as changing, amending their policies, their rules and regulations, taking fair housing training. And this will be overseen either by a group, by Project Sentinel. We oversee affirmative relief through several years frequently, or by the agency, administrative agency itself, by HUD or DFEH, or by another fair housing organization. Going on to the next slide. Again, this is the injunctive relief and the punitive and actual damages. If a court finds that a discriminatory housing practice has occurred or is about to occur, the court may award the plaintiff actual and punitive damages and appropriate relief, including restraining orders, permanent or temporary injunctions, and affirmative orders. Going on to the next slide. We want to emphasize for interested attorneys that there is an attorney's fee and cost recovery by statute in any civil action. The court, in its discretion, may allow the prevailing party other than the United States, a reasonable attorney's fee and cost. Parties, including government parties, including the United States, can be liable for those attorney's fees and cost to the same extent as a private person. These attorney's fees are awarded regularly in cases that either are successfully resolved in a mediation or settlement process, or obtain a successful judgment. Going on to the next slide. And this slide concerns section 3631, which is part 2 of the Fair Housing Act. It's the only section in part 2, but it really concerns the intersection between civil law and criminal law under the Fair Housing Act. This section provides whoever, whether or not acting under color of law. So it includes persons who might be acting under color of local or state or federal law, who force or by threat of force willfully injures or intimidates or interferes or attempts to injure, intimidate, or interfere with a person's right under the Fair Housing Act to sell, purchase, rent, or lease dwellings free from discrimination based on race, color, religion, sex, national origin, or handicap, shall be fined under Title 8 or imprisoned. And that imprisonment term will be based on, if you review this section, you will see it's based on the severity of the willful act of injury or intimidation. It can be up to 1 year, or for actions where there's actual physical injury, or whether there's actions that involve really criminal actions such as use of weapons or fire, or actions that concern kidnapping or basic crimes. Then the term of imprisonment can go up to 10 years, or finally up to a term of years, including a life term. So this is a very serious section that looks back to the history in the United States, which we have a long-standing history and current history of acts of intimidation to force people into certain types of housing, certain neighborhoods, and to deny them other housing. If we can move on to the next slide, please. This act goes into the to the California Fair Employment Law as compared to the federal law. The California law protects all these same classifications of race, color, religion, national origin, sex, familial status, and disability, but it also offers a broader class of protections. It'll protect marital status, that includes being single or being married. It includes both heterosexual marriages and non-heterosexual marriages. It includes sexual orientation. It includes ancestry. One of the more recent protections is for source of income. In this, we see Social Security income, voucher status income, where a person is being provided part of their rent through a voucher program. We also are finding a concern in COVID for rental assistance that's related to COVID. rental assistance. So an individual can't be discriminated against based on the way they manage to qualify for the housing, and that qualification may include Social Security income, voucher income, or rental assistance income. The California law also protects gender identity and expression, and there's also protections under the Unruh Civil Rights Act for immigration status, primary language, citizenship, and arbitrary characteristics such as age. We sometimes again see a number of these characteristics coming together. We have a case now that originally sprang out of discrimination against a tenant's emotional support animal, a small dog. Once this landlord learned about the dog, they became very upset against this tenant, and they started using all sorts of bases of discrimination. And so while they had encouraged the person to seek rental assistance, after they learned about the dog, they refused to participate in the rental assistance program, while they had been happy to rent to an immigrant after the dog was discovered or learned about. They suddenly became concerned about the person's immigration status and began broadcasting statements about the person's immigration status, which were untrue, actually. And they also became involved in the person's church and broadcast discriminatory statements against this person. So we see a whole intersection of protected classifications coming together to discriminate against this person and to retaliate against them. It's an interesting case, but also a complicated case. I think going back to the slide notes, I have included those so they are available to you. They are much more detailed than I actually have presented here, but they do include citations to the California Fair Employment and Housing Act, which is located at California Government Code section 12900 at SEC, and the Unruh Civil Rights Act, which is sections 51 and 52 of the California Civil Code. There are a number of case citations in the notes that may be helpful to you. I also would invite anyone who's interested in knowing more to email me, and I can provide you a bibliography of Project Sentinel cases and some of the cases that we regularly rely on. I'd also be very happy to talk to you about becoming a panel attorney for Project Sentinel. I'm going to turn it over to questions at this point.
Great, thank you so much, Lark. And all of those resources she just mentioned, I will send out to the attendees today. So we do have one question from the audience that is, have you had any successful cases with trans clients due to discrimination on sex?
We have had successful administrative action cases before HUD and before DFEH. We do get a number of trans clients that we call in for intake matters for various concerns. And some of those cases are resolved through conciliation and through education. We do get cases that involve people of various sexual identities or sexual orientations, and they may be facing discrimination and retaliatory acts. Often what we will find in their stories are things like, maybe a couple, and one person in the couple is more traditionally classified, maybe a white person, or and the other person is less so, and so the housing provider only talks to the person they feel comfortable with. Or these people, what we find is people who are different from other tenants in one way or another, which may be trans or some other gender classification, will be targeted in ways that other tenants are not targeted. They'll be accused of being the noisy tenant. They may be accused of that when they're not even home, when they're at work. They'll be accused of being the car that drives into the parking lot with the bass beat booming when they won't be even around, or that person may not even have a car. So we often find that we're dealing with kind of negotiating through these discriminations and acts that occur largely, I think, because of people's discomfort with dealing with people that are not the same as themselves. Everybody has those kinds of discomforts, but in fair housing, it's not an appropriate basis of denying housing or treating someone differently or retaliating against them because they bring up a fair housing right.
Great, thank you. And we actually just had one more question come through. Can you walk us through the DFEH process? I've heard it can take several months for things to begin.
And we're talking about administrative action before DFEH, is my understanding of that question.
They clarified,
Okay.
That's correct.
It will start with, so any person who has believes they are being discriminated against based on a protected classification has a right to file an administrative complaint to DFEH. They can do that on their own, and there's the website has places that will lead the client, the person, the individual through that complaint process, and they can file that on their own. Or they can turn to Project Sentinel or to a similar organization, and Project Sentinel will represent that person as a client and draft the complaint for the client and file it for the client. So we will be listed as their attorney, and we often do this in a pair where we're having a staff attorney on the complaint and a housing coordinator who is not an attorney, but who is trained in investigation and will have a lot of information and knowledge about the case, who may have actually done more investigative work on the case than the attorney. We will have them both on the complaint. And yes, once the complaint is filed by Project Sentinel, it may take several weeks before it is taken. DFEH has its own intake process. So they review complaints to make sure that they are good, that they're timely, that they're within the statute of limitations, that they involve a classification that is protected. So they have their own review process. If they think there is something there that's not correct, they will call us up and ask us for clarification. And once they intake a case, they will assign it to a mediator. And that mediator will review the case and will contact both sides and will seek to resolve the case through mediation, through conciliation. And often the case will be resolved that way, and there will be a conciliation agreement. It may involve the same kinds of relief that a case that goes before the administrative board or into a court would involve. In other words, there may be damages that are agreed to. They'll not be admissions of liability, but there'll be settlement agreements that involve awards for damages. There'll be agreements about relief type actions, affirmative relief. So things like changes in policies, training in fair housing, and review by Project Sentinel or by the agency itself for a period of years. If a case does not resolve in mediation, it will be assigned to an investigator. That investigator will review again, both with the complainant and the respondent, and they'll look at all the evidence each side has. They'll ask for evidence on certain issues. They will have, lately it's been Zoom meetings, but they will have conferences where one party is asked to bring not only the attorney or the housing coordinator representing the client, but the client will also be involved and will provide testimony. And that investigation will resolve in either one of two things: in a letter of a finding of no cause. We don't like those letters, but sometimes they occur for a variety of reasons. One reason we find is a frequent reason for a no cause letter is because there is no supporting evidence beyond the parties' statements. In other words, it is a swearing contest. We try to get beyond swearing contests with our investigation and with testing and surveys. But if it is a swearing contest, they may warn us that they're going to issue a no cause letter. Project Sentinel will try to get that warning and will dismiss the case before the no cause letter comes out. And then we may try to bring that case be in a court action. The other thing that will happen is that it will be referred to the administrative board for a hearing. And this may take quite a while. But then there will be an administrative hearing before an administrative officer, and it will be similar to a court hearing. If you have more questions about that process, I'd be happy to answer them. You can email me and I will contact you. Thank you. And again, thank you to Danica and to ALRP.
Great. Thank you so much, Lark. Thanks for everyone for joining. I'll send out those materials by email and also Lark's email in case you want to reach out to her directly. Great. Thank you so much, everyone. Have a great day. Thanks, Lark.
Thank you.